call the first case on this morning's docket. Case number 117989, Linus Baker v. Calvin Hayden et al. And Catherine Stocks.
Mr. Chief Justice, may it please the court, Joe Colantono. I represent Catherine Stocks, who is the petitioner today and who was the defendant in the district court. I would request 3 minutes for rebuttal, if I may.
3 minutes is granted.
I'd like to begin by first explaining the procedural history that brought us here and some of the very basic facts. The first seminal or trigger event was a protection from abuse order from the District Court of Wyandotte County in McCormick versus McCormick. That Wyandotte County order required the return of one of two children, the appellant's grandchildren, one of those two children to Ryan McCormick. On September 2, 2015, the Johnson County Sheriff's Department, not Wyandotte, Johnson County Sheriff's Department went to the appellant's home to serve the PFA order and to retrieve one of the two grandchildren. When the sheriffs arrived, they picked up one, took that child to the curb to show to Mr. McCormick, who was there waiting. He said, "Nope, wrong child." There was a discussion. At some point, one of the sheriffs touched Mr. Baker on the shoulder or on the arm, and eventually everybody left. The next day, September 3, three Johnson County sheriffs returned to the Baker home to attempt to serve the Wyandotte County PFA. They walked around to the back of the house, walked on the yard. That became the subject of a federal court lawsuit that Mr. Baker was not a party to, but his wife was. And it became the subject of this suit here. Then we go to the next day, September 4, 2015. There is a hearing in Johnson County on McCormick versus McCormick divorce. 4 days later, September 8, 2015, there was another hearing in Johnson County on the McCormick versus McCormick divorce. The audio recordings of those September 4 and September 8 hearings are the focus of why we're here today. Shortly after, within 2 weeks after those hearings, appellant submitted a Kansas Open Records request asking for the tape recordings. His requests were denied based upon 45-219A, denied by Catherine Stocks, whom I represent. There's further correspondence. They are denied based upon 45-221A20. Mr. Baker then filed a mandamus in this court, and that mandamus proceeding seeking the recordings was denied by this court. Eventually then, he sued both Catherine Stocks under the Kansas Open Records Act and the Johnson County Sheriffs, suing the sheriffs based on what happened September 2, September 3. That suit was in Johnson County. That case involved two branches, one against Stocks, one against the Johnson County Sheriffs. The district court, Judge Fairchild, dismissed the claims against Stocks in February of 2017. But in the month before that, Mr. Baker received the audio recording. Hence, the mootness issue has arisen. After dismissal, there is an appeal by Mr. Baker. On April 6, 2018, the Court of Appeals entered an order. The Court of Appeals order said that the issue here is one that is capable of repetition and involves public importance, and it can be said with assurance there is no reasonable expectation that the alleged violation will recur. I'm sorry, I said they cannot make that conclusion. And the Court of Appeals concluded that this matter was not moot, even though Mr. Baker did have a copy of the recording.
How did Mr. Baker have standing to pursue that appeal? Or did he have standing to pursue the appeal?
If that is the jurisdictional issue that the court alluded to in its recent order, I believe that he had standing because he had submitted a request. I believe that ripeness...
But no, arguably at least, no court action, there was no relief that he could, that the suit could deliver to him. What relief could the lawsuit provide to...
It could not give him something he didn't already have because he had the recording.
Isn't that a component of standing, a necessary component?
I don't know that it's a necessary jurisdictional component.
You have to be able to show a concrete injury that's redressable.
The delay in providing the recording, I believe, is arguably...
He wasn't seeking any damages for a delay, was he?
Yes, Justice Stegall, that is correct. He wasn't seeking, and is not at this point, seeking damages.
And if he lacked standing, then the Court of Appeals, at least arguably, did not have jurisdiction. Would you agree with that?
I'm not ready to agree with that because I believe that if the issue is moot, that is not necessarily a jurisdictional issue.
But standing's a little different from mootness. And I understand both sides are in front of this court saying, please answer the question. My concern is really more fundamental, whether we have jurisdiction or whether we're just being asked to deliver an advisory opinion.
You may be in a position where you're being asked to deliver an advisory decision or opinion, but that doesn't make this moot. And if I could, let me point to a case that this court denied a petition for review on exactly 1 year ago, October 30, 2018. In Clark versus Unified School District, a Kansas Open Records Act suit. The appellate court said the case was not moot under the Kansas Open Records Act, even though Clark, the plaintiff, already had the letter that he was seeking, just as Mr. Baker already has the recording. He got it through pretrial discovery in his suit. He didn't get it technically in response to the Cora request. Just as Clark had the letter in Clark versus School District, Mr. Baker, appellant, has the recording. Court of Appeals in that case said, moreover, statutory interpretation of an exception to Cora is clearly a matter of public importance and an issue capable of repetition. Clark's claims regarding the Hurt letter are not moot.
Even if you're right that it's not moot, don't we still have to engage in the standing analysis?
Because that's subject matter jurisdiction, isn't it?
I'm not sure that it's subject matter jurisdiction. I think it's a question that can be open to exceptions, just as mootness.
I don't think we've said that, have we? Mootness is a prudential doctrine, and jurisdiction is not.
Agreed.
So if standing is part of jurisdiction, and we would say that he has no standing, we don't have jurisdiction to hear the case, neither did the Court of Appeals.
Well, I think that there was standing when the suit was brought. The records were not provided pursuant to Cora. They are provided pursuant to pretrial discovery. And I believe that there was standing. I cannot point the court to a decision that specifically says that there was standing. And I'm in a bit of a peculiar position of saying today, we think there was standing for the claim to be brought. And I'm saying that because I think it's plausible, number one. Number two, we are looking for a substantive ruling in the district court and in the Court of Appeals when the Attorney General's office was representing Stotts. At both levels, the Attorney General's office argued that the matter was moot. We are reversing that position because we believe this is a significant issue capable of repetition, and here's why.
But that is all a mootness issue. which is not jurisdictional,
Agreed.
right? And standing is.
Agreed.
So we can't hear the case if there's no standing. So I think maybe what Justice Stegall is asking is, tell us why there is standing.
They were standing when it was first filed, and there was not a response pursuant to the Kansas Open Records Act. I think that the disclosure...
Are there cases that say once standing, that standing is sort of, you look at it at the frozen moment when the case is filed, and you can't lose it afterwards?
Justice Stegall, I would like to be able to answer that question, but quite frankly, I do not know of cases that say it stays with you throughout the entire case. I just don't know the answer to that. But here's why I believe this is a matter of public importance, as the Court of Appeals said, and as was stated in the Clark case. For the reporting year 2018, there were 8,308 protection from abuse filings in Kansas. 8,308. Same reporting year, there were 22,061 felony cases filed. That's just Kansas. 1 year, 22,061. There were 11,457 divorce cases. It takes just one of those 8,000 PFAs, 22,000 felonies, or 11,000 divorces to bring this issue up again. And I believe if it comes up again, the repercussions can be significant. I recognize the court has declined to hear the issue we brought when we submitted affidavits that were outside the record from court reporters regarding the potential repercussions when at the table if attorneys speak to their clients and it comes across on the recording.
I understand. I want to talk about a little bit on the merits, the nature of the request, and that is for an audio recording. And just what is that audio recording? Your position is that it's more akin to notes. Is that correct?
Justice Rosen, that is not our position. It has been.
Okay, what is your position as to the nature of the request as it pertains to the audio? What is an audio recording? Is it a device by which the court reporter then makes an official court transcript, or what is the audio recording?
They're not notes in the handwritten sense, but they are a tool that the court reporter uses to prepare the final transcript. They're not the transcript, but they're not handwritten notes, but they do fall within the category of 219A.
Is it any different than, having worked with court reporters in the past, is it any different than from the stenographic machine and the paper that comes out, and then from that a transcript is made? Is it technically any different than that?
From a legal standpoint, I do not see a recording as any different than the paper notes that come across looking like hieroglyphics to somebody like us. I think they're the same. I think they're notes. They're not the final transcript.
That was my point.
Yes.
Is that it's an aid. The recording is an aid by which the official transcript is then completed.
Yes, Justice Rosen, and that is why it fits within 45-221A20. But the decisive issue that the district court relied on, and that I believe is the proper focus, is Supreme Court Rule 362, which says, quote, upon request of counsel, the clerk of the district court shall make arrangements for counsel to review the electronic recordings of the case involved. On request of counsel, counsel can review. Doesn't say copy, only review, and only counsel. Then we turn to 221A1, which says records, the disclosure of which is specifically prohibited or restricted by rule or the Kansas Supreme Court are exempt from disclosure. I believe by saying that it's only counsel and only review, that is a restriction. And that triggers 362. And I struggle trying to understand the Court of Appeals rationale that there's no way that 362 is a restriction or prohibition. I thought, how could you come to that conclusion? Because I think it's not ambiguous. At pages 14 and 24 of appellant's brief, he said it is not ambiguous. When the American Civil Liberties Union submitted its amicus, they said 362 is not ambiguous. So I thought to myself, how could the Court of Appeals see it that way? And I thought, let's just look really basically. If it's a limitation on who can see it, is that the same as a restriction? And so
Counsel,
I went to the Old Faithful.
Counsel, let me interrupt you because I don't understand this whole, I really think the plain language of the Supreme Court rule and 221A20 don't help you. I mean, I don't have that reading, but here's my question. Why aren't you just hugging and embracing 45219A, which says that recordings aren't public records and aren't subject to required disclosure if they haven't been played in public?
That was the initial reason that was provided by Stotts.
I know
It was
that,
valid
but I'm just
reason.
saying, why isn't that your legal argument?
Well, it's in my notes and it should have been up front.
I just, because the Supreme Court rule does not restrict access to those tapes. It simply gives a right of access. Doesn't prohibit anybody from doing anything else. And so I just don't see it. But I do see a really good argument under 45219A, and I don't hear you emphasizing it.
Well,
Which causes me pause about whether I understand what's going on here.
219A fits, which is why it was the first reason that Stotts provided for not providing the recordings. I mean, it's in my mind very clear. 219A says a public agency shall not be required to provide copies of a recording unless it is played to a public meeting. I think that's very clear. Questions have been raised. Well, was that intended to apply to exhibits or evidentiary type recordings?
What difference does it make if it was intended or wasn't intended if the plain language of the statute covers the situation?
I don't think it makes a difference because I think the plain language covers it. And I would draw the court's attention to its ruling in Baldwin versus Farmers Insurance in 1980, talking about statutes and would it be helpful if there were another phrase inserted or not? Well, in Baldwin, this court said even if the legislature does not contemplate the occurrence which confronts a court in construing a statute, that court may not supply omissions in the statute. I don't think it's necessary to supply additional language in 219A.
I have one other just quick question. You mentioned this Clark versus school district, and I didn't see it in any of the filings that I have, and I did a search in our folder. So can you give me a docket number or a citation to it?
I can, and the Kansas Court of Appeals decision in Clark versus Unified School District was 55, Kansas Appeals 2nd, 402. The appropriate language is at 408.
Okay.
The review was denied on October 30, 2018, and I believe the citation is Lexus page 631.
Counsel, I have a question.
Yes.
I'm just trying to understand the motivation for wanting a substantive ruling on your side of the case and for the switch in position on mootness. Is it that you're fearful that the Court of Appeals decision will stand and be cited in future cases? Is that what you're getting at when you recite the statistics about how many PFAs there are, et cetera?
We want direction because this is an issue that is capable of repetition, phrase that the courts have used regarding mootness, and we would like some clarity other than the fact that it's been addressed as it has by the Court of Appeals. We believe that disclosure is not required and that the recordings are exempt under 219A.
So silence from the appellate courts isn't good enough. That's what I'm getting at, because obviously if we were to rule that there was no standing, then the Court of Appeals decision has no effect or force. But that's not good enough for you. You want
Silence from the Court of Appeals is not our first choice.
Okay.
Correct.
All right, thank you.
Do we
I've
have
used up
any-
my
do we-
time.
Do we have any further questions? Counsel, we've taken a lot of your time with our questions. Do you need about 30 seconds to wrap up, or do you want to wait till rebuttal?
I'll wait till rebuttal. Thank you.
All right, thank you.
May it please the court, Linus L. Baker, attorney appearing pro se. Let's start with standing. Standing is determined at the time you bring the suit. That's Hornbook law. I don't have the citation. I thought you were going to go with separation of powers when you threw up the jurisdiction. I didn't think standing.
Well, let me ask you about what you just said, that it certainly is determined at the time you file the suit. In other words, you have to have standing at the time you file the suit. But in a circumstance, do you know of any case that tracks a similar circumstance to this, where the relief that the plaintiff is seeking was fully afforded and the plaintiff wants to continue the lawsuit to a legal judgment?
Well, I think yes, because if you determine standing at the time the suit is brought, you don't lose it.
Well, that's what I'm asking. Do you have a case that says that?
I wished I were that smart and had all that citation. I did not realize today that was the question and answer session on that, so I apologize.
But the position you take today is that once you had standing, you can't lose it.
Correct. Now, and because otherwise, if standing is not determined at the time you bring the suit and it becomes a moving target, then that rule becomes subsumed. It means nothing. So I had standing.
Well, what's at stake here now that I guess you as the client have received the remedy?
Now you're back to the mootness issue, because now it's capable of repetition. In other words, I made a core request. They didn't give it to me. I had to file a lawsuit.
Let me back up.
Okay.
If Catherine Stokes had given you the recordings you asked the day after you asked for them, you would not have had standing to bring the lawsuit, correct?
I would not have been aggrieved.
And now that you've received what you requested, your position is you can still proceed.
Yes, for several reasons. One is they continue to take the position they're not open records. Fits perfectly within the mootness issue. And they say, look, if they are open records, somebody shouldn't have to file a lawsuit and then get it in discovery, and then it goes away again. It's just going to repeat itself over and over. It is a matter of public concern, Your Honor. So
if we have a personal injury plaintiff asking for $1 million in damages when the suit is filed and the defendant says, here's your $1 million, it's your position that person could proceed if they think they have a matter of public importance. Is that right?
The analogy there isn't on 4, because I'm looking for declaratory relief here. In other words,
why can't you file an independent declaratory judgment action?
Well, I did file an independent action, and I said that what they did was wrong, and that they should declare, Your Honors, the law that those are open records.
Did you ask for declaratory relief?
That lawsuit I can't recall, but I certainly built within it asking for declaratory.
You wanted the tapes.
I wanted a declaration that those tapes are open records. Sure, I don't want to have to go through this as soon as we get through here, I go make another request. And where do we go from there? They want that answer too. I submit I had standing, and I submit that I was aggrieved. I asked for attorney's fees.
Counsel?
Yes.
Mr. Baker? We're asking, what did you plead? Did you plead declaratory relief?
I think I did. That whole suit was brought together. But like I say, I think I did ask for it. I asked that you declare that those records are open. And Judge Fairchild, in response to that, said, no, they're not. I don't know what else I could have asked for that would have gotten that statement from Judge Fairchild. So I think the standing...
Excuse me, counsel. You certainly asked for a holding that the public records law applied to this recording that you're seeking.
I asked for more than just getting the tapes.
That has to be I understand, but I'm not sure what we have up here. I don't think the attorney's fees and stuff is up here. But
no.
My point is, the necessary first step for you getting your relief was a finding that the law applied to this particular item.
That's correct. In other words, unless you declare they're open records, I don't get the tape, or I don't get the recording. So I had to ask for a declaration that they are open records. I want to address, if there's, to move on, this 45219 issue. It's a square peg in a round hole. Public agency. And it talks about a governing body. That's a term of art that's used, for example, in 105A, the Tort Immunity. It defines governing authority, and those are boards. Those are those kinds of things. Public agency. I don't know if the court's called a public agency, but it does not fit. A governing authority then has to do with COMA, open meetings. It says a public meeting. So you're really trying to fit within that framework something that can never apply in terms of court recordings. I don't think you're a public agency. I don't think you ever have a public meeting. You're not required to. Who would be the governing authority? It just does not apply. Let's move to the second part of 45219. It does not say that you can't get access. 45219, in fact, makes a distinction between access and copies. It says we can charge you fees for access, we can charge you fees for copies. 45219 says we just don't have to make you copies. Okay, fine. I want to go listen to it. I want to go watch it. All right? So that's not a prohibition to that. Now, the footnote to that is, let's say I get to listen to it. There's nothing in 45219 says I can't make my own recording while I listen to it. That may be for another time, but it does not prohibit access to these records. Even if you could pigeonhole, you got to remember, 45219 was made when the dinosaurs roamed the earth, technologically speaking. Photos were not digitized. It was all paper. They talk about radio and tapes and all that. We're way beyond that. You'd have to say that the electronic files and GIMs, they're not on a quote-unquote disk. They're in a server. They're in a computer. So the language here, you'd have to modify it, add to it, to make it sound like it prohibits anything in a computer server.
Could you address the issue concern that was raised about the confidentiality that oftentimes these recordings pick up?
Well, you didn't take that issue up on
excuse me,
the
that's
petition on
right,
appeal.
yeah.
A and B on these two different rules. I'd be happy to, because I think if you've got mics here and attorneys know it,
It's called mute buttons, right?
Right. Don't say things. So the copies. So it does not prohibit. And so think about this. Let's say, just try to apply 45219 to a county commission meeting. County commission meeting records. They have the audio. And so now they archive it. I ask for an open records. They say, Mr. Baker, you cannot even listen to this. In fact, you can't get a copy until we go back around the corner and they have a second meeting and we play it for them again, or, let them hear what they said in open, and then now you can get a copy. It's an absurd kind of reading. Why would they say, because look, what they're talking about here is photos and things that are not out for public consumption. They never were public. And they say that, look, if you take it, you go to the time and you present it to the governing authority at a public meeting, then it's public consumption. So the intent there is it can never apply to the public meetings recording itself. In fact, 754318 says I get to make my own recordings of a public meeting. I can go in there and do it. So it's an absurd idea that say, hey, I made my own recording. Can I have your recording? No. You can't even listen to it. So it's a square peg in a round hole. You just can't apply it. Let's talk about 362. 362, they say, well, if we give you access or means to get a record, then that's your sole remedy. Well, there's lots of rules that this court has that give attorneys access to records. I get to look in the Johnson County gyms, and I get to look at all kinds of records that the public does not get to. Does that mean then, because I've been given access, eyes only, by default that means that it's not an open record? For example, I can, the record on appeal. I can get that. Does that mean the record on appeal isn't public? I can check out, in the old days, you used to check out the court file. I could check that out as an attorney. Public couldn't do it. The fact that a rule gives me that right, does it mean now the court file is not an open record? No. So it would lead to absurd results every time you say that attorneys get to do something that the general public does not. It just simply means this. I don't have to file an open records request every time to get something. So if I'm fussing with the court reporter about the transcript, then you've got a rule there. They've got a rule that says I can get access to that recording without filing an open records request. It doesn't mean nobody, that's the sole remedy there, no more than any other rule. So the issue here then is why is Johnson County doesn't want those audio recordings disseminated? I mean, I think of why. What is the reason? It's a public meeting. It's simply there in the server. They use it. Court personnel use it. You can punch a button, just listen to it. What's the big deal? Well, the big deal is this, I think, is that they use that as a way to leverage court reporter money. It's the only thing I can think of. And why would I want to listen to it? Well, ask the person to a blind man. I don't want to get a transcript and get translated into Braille. I just want to know what's happening, just like the 2 hearings. I wasn't a party to it, but I darn sure wanted to hear what happened in that because the sheriff's department said they were going to file charges on me, which, and all that. Now, that's another subject of appeal before this court. Judge McGee in the federal court has already ruled that the Johnson County Sheriff's was out of line. But I wanted to hear, what did you all say about me in that hearing? All right, legitimate. And eventually they gave it to me after I filed a lawsuit, after I asked for discovery.
Counsel, let me dial you back to 45-219 to make sure I understand your argument. You've indicated that it's not applicable to the recording of that hearing because the court is not, I think you used the term governing body, but I don't see that term in the statute.
It says that
It says public agency, and public agency is a defined entity. Is it your position that the court system does not fall under the definition of public agency?
that's not my main argument. I don't know one way or the other. It does use governing body, though, in that statute. It says that unless such items or devices were shown or played to a public meeting of the governing body thereof. So you got your element.
But that's the access part of the statute. It's
Yes.
saying if you've got a recording out here, the only way you get to it is if it's played publicly before a governing body. But the record itself is of a public agency. And public
That's-
agency is defined in 45-217 F1. And I read that definition to include the court system.
Fair
Am I
enough.
right or wrong?
I will take your word for it.
And if that's the case, then that means this recording falls under this definition, and the only way it comes out is if it's played to a governing body, which hasn't happened.
All right.
So
And
how
who
does
would be
this-
the governing body at Johnson County court system? They don't have public meetings.
It doesn't matter if it wasn't, if the statute identifies something that doesn't even exist, but it says that it has to be played to that non-existent entity, then it still stays subject. It's not subject to disclosure under this act.
Well, let me just
What am I missing?
Well, because you have to take it all together. It says a public meeting of the governing body.
Right.
You all don't have that.
Which means it doesn't come out.
Well, I would submit it means that statute doesn't even apply. In other words, it would be an impossibility to say that the legislature intended this would never apply to recordings of a commission's own public meeting. it's it would be nonsensical to say, we'll say a governing body in a public meeting, but that would never apply to the court system. You don't have open meetings. You don't have, who would be the governing body? So by its own terms, it does not apply.
Counsel, I see you're out of time. What are you asking us to do?
Well, I'm asking you to declare that these audio recordings are open records.
All right. Do we
I have
any further-
Sure.
more quick question. It sounds like, but I want to be certain I understand your argument, that at least part of your argument is that there's a difference under the open record scheme between copying and having access.
Yes, there is. You
that-
can not be required to make copies, but you can be required to give access
So
to.
I'm understanding you correctly that at least one of your arguments is that 219A might apply to restrict your ability to obtain copies, but under other portions of the Open Records Act, you still have a right to listen.
That
Or a
is
right
correct.
of disclosure. The statute uses these two words, copy and disclose, and I'm trying to figure out if they're supposed to be sort of mean the same thing or mean something different.
Well, 45219 says access. If you look through there, it uses the phrase access. And they can charge fees to access the record and charge fees to copy. So the access question you're asking about, the nomenclature is the same as the right to inspect. Give me access. You don't have to make copies. Just let me go listen to it. That statute doesn't prohibit that. It simply says we don't have to provide copies. So I think I still win under that provision.
Thank you, counsel.
May it please the court, I'll be very brief. I believe that the district court was correct when the district court said that Supreme Court Rule 362, in conjunction with 45-221A1, exempts the recordings because they are a restricted record.
Let me just ask a practical question.
Yes.
Why in the world is Johnson County District Court fighting so hard to keep these recordings secret when any citizen could have walked into the courtroom that day and just sat in the... We have citizens here. They can come sit and observe and watch.
My response, which is a bit speculative, is simply that the district court wants rules and understanding and clarity and feels that when the rules say something is disclosable under CORA, that's what should be followed. I think it's maybe simply adherence to what they believe is the governing law. So, we believe the district court was correct when it applied 362 and statute 45-221A. We also believe that Ms. Stocks was correct when prior to the litigation, she relied on 45-219A, Justice Biles' issue, because recordings that are not played at the public hearing are exempt. There is a third basis for these recordings to not be subject to CORA, and that is 45-221A20, because they qualify as preliminary drafts for the reporters to look at to help prepare the transcript, just like the paper that spews out of the court reporter's machine is reviewed as a note. So we're requesting that this court, number one, affirm the district court's conclusion that this is not moot. Number two, reverse the district court regarding the applicability of the exemptions, and that this court apply the same exemption that the district court applied.
Counsel, why don't we just wait until we get a real case here in which someone makes a CORA request and that request is denied and they never get the documents or recordings they're asking for?
Chief Justice, I believe that that is an argument that can be used in every case where there's a question of mootness. And for whatever reason, the courts historically, including our courts, say that when it's capable of repetition and it's a matter of public importance, which CORA issues are, that the courts will address it anyway. That's why.
Do we have any further questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.